46 days from then to actually ask for the writ. But reality is about to land on him, and I'm not sure he's ready for it.
Yeah.
All right. Do you have any questions?
No, thank you so much.
All right. I wish you good luck. This is a tough call. I know it was hard for you to make. All right. You're good to go.
Thank you.
Thank you. All right. That was another one of my classmates that comes to court. I'm still trying to figure out who Seth Thorpe is, but my next case is entitled Richmond versus Richmond.
I'm not evicting Larry.
Well, maybe you should. Apparently we brought our audience to tears. Frank had to provide some help. All right, this is entitled Terry and Larry Richmond versus Erica Richmond and any others. Let's see, I've got a couple people in the waiting room here.
I don't think she's going to come because she moved out, but she didn't turn in keys. She just left me a note saying that she no longer lived there.
How do I turn on the camera? What's that?
All right, I've got a couple people that have come in, Trenton Young and somebody by iPhone.
It's you.
Whose iPhone, ma'am? What's your name?
This is Stacy Rumler.
All right, let me give you a name.
Start.
Mr. Thorpe, can you hear me?
Yes, sir.
Which case are you here on?
Young and Rumler.
All right, your case is coming up at 9:20. All right, so you're the plaintiff in that case. I'll be with you in a minute. All right, right now we're at our other 9:20 case. We do have personal service in that matter. And I do have a judgment. Defendant has moved out, left a note, does not appear. All right, I find by default that this defendant is subject, both defendants are subject to being evicted. The date for the eviction is 9/7/26. No money charge. I'm going to indicate that if defendant has vacated, plaintiff may have immediate possession.
Thank you.
Date for the appeal is 9/7. This premises is on 4th Street. All right, Miss Richmond, I'll see you next time. Thank you.
Okay. Thank you.
Thanks for the judgment as well. All right, we've got some other cases coming up here.
Your Honor,
Yes?
I think I have another case.
Oh, yeah, Richmond and Olds at 9:25.
What did you
Thorpe and Rumler is at 9:30, so it is 9:30, so let's call your other one. Terry and Larry Richmond. Versus Nicholas Altz and any others. Mr. Altz is not here. We were here last week. Defendant called and said he had to work. The arrearage was 154.65. Wasn't very substantial. He expected he was going to pay. He's not here again today. Ms. Richmond, what's the status here?
He owes, he did pay some more, and he owes 117.15 through 9/3.
And what are the court costs?
Oh,
We got 110 and 39.45. So that's 149.35. All right, I find by default through 9/3/26, the defendant owes 117.15 in rent and 149.35 in court costs. $266.50. Not substantial. You expect this to be paid?
yes, I do. This video is stopped.
I'm going to enter the default judgment. The date for the writ is September 9th. Partial payment will not prevent the writ of eviction. No money judgment is issued at this time. And additional costs could be accrued after September 3rd. 9/7 is also the appeal date. All right, Ms. Richmond, that was two straightforward matters.
Yep.
I'll see you next time.
Okay, thank you.
All right, now we're up to Mr. Thorpe and Rumler. We've also got Trenton Young. I'm not sure which case he's here on. Frank, could I have a Kleenex too? Mr. Young, what case are you here on?
Thorpe.
Kleenex. All right, so it's Rumler and Young. All right, we got both parties. Thank you. All right, this is filed as a demand for non-payment of rent. Rent is $1,500 per month. This premises is on North Main Street in Three Rivers. I believe it's one of the downtown stores. Let me see who else is here. Mr. Singh. All right, you are defendants in a landlord-tenant case. In such a case, you're entitled to hire a lawyer. We don't have court-appointed attorneys in landlord-tenant cases, but our representative from Legal Aid is here and viewing this. You may hire a lawyer or seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to ask for a jury trial. If you wish to have a jury trial, you must tell me at this first appearance or be prepared to file a written demand for a jury trial within 5 days and pay the $50 jury demand fee. If your landlord is asking you to pay rent at a residential property, you may be able to get some emergency financial assistance from Department of Health and Human Services, Community Action Agency, Neighborhood Inc., Salvation Army, other funding source, or if you're a veteran, you may be eligible for some emergency veteran housing funds. You may request, first time today, somebody actually suggested mediation. You may request, if both parties are agreeable, to submit the matter to mediation for an attempted resolution. And if both parties can agree on a settlement, they could file something called a conditional order of dismissal. Ms. Rumler and Mr. Young were both personally served. They are both present. As I indicated, rent is $1,500 per month. What building is this? What's below 15 North Main, 15 and a half?
Ashley Hit Boutique.
Okay. So is this the apartment above it, or is this the store?
The apartment above it.
All right. Ms. Rumler and well, first of all, Mr. Thorpe, what's the current arrearage?
3,000.
So that would be July and August rent?
Yes, sir. Yes, sir.
Are there any late fees?
Yes, 300.
Say that again.
300.
How much are late fees?
150 a month.
You can't charge 150 a month.
That's what he
I'll-
does. Even
right,
if
well, you
you're a
can't
day
charge-
late.
All right, well, I'm gonna allow $50 a month.
Judge, my phone died.
You're fine. I can hear you and see you. All I could see was your hair before, so.
Yeah,
This
he's
is
got a lot
fine.
of hair.
Well, I get that a lot. So does Mr. Rognus.
I was wondering, like, after everything's done, if I could make like a little statement about some issues.
Yeah, let's figure out the money issue first here.
Okay.
We've also got court costs, which is a $50 filing fee and $242.53 service fees. So 55 plus 42.53 plus 42.53 is 140.06. There is no attorney fee. Wait a minute, I'm looking at the wrong case. The file, I was looking at the next case. In this one, the court costs are 130 filing fee. And 241.06 service fees. $212.20. That's not right. $212.12. If we add that to $3,600 and a $50 late fee for 2 months. We get $3,312.12 through August. Another $1,500 will be due September 1. Yes, Ms. Rumler, what would you like to say?
Okay, so since we have went to Seth, we have had a number of issues. When we had the tornado, we were without power here for 4 days. We had to stay in a hotel one night. The ceiling in the one room completely collapsed. I had notified Seth, and it took him over a month to even come fix it. And he had a bunch of teenagers come, and all they did was nail stuff together on the ceiling. And so my daughter's got a 2-month-old baby. We can't even put him in there because we know that those nails in the ceiling are not going to hold.
All right, well, let me ask you a question. Do you wish to move?
We are in the process of moving. I mean, so what happened with getting behind on rent was I had went to nursing school at Glen Oaks, and working full time, I was struggling to pay. But then he throws out these $150 late fees, and every time, even if you're a couple days late, and he wants you to deliver the rent to his house in White Pigeon, and I am not comfortable with delivering the rent there because he's got a bunch of underage minors there drinking and smoking every time I go there.
Mr. Storff, do you own the building or do you manage it for somebody else?
I own the building. I would like to say, wait on rent every month except for one, and I only charge a late fee one time.
All right, well, you can't charge a $150 late fee. The law is not really clear on what they are, but you can't charge that much.
We have it in text saying that he does it daily.
Yeah.
I didn't charge.
And, all right, let me see what else. The law, you require them to come to your house and pay the rent in cash?
I don't require them to come to the house, but they gotta give me the rent.
Yes, you do.
Yeah, you do. You say that you will only.
All right,
you can
stop. There is a lease, which is better than some I've seen. At any rate, there does appear that July's rent hasn't been paid and August rent hasn't been paid. There may be an issue that rent should be abated or reduced because you were without power for a couple of days. On March 6th, when the tornado hit, a lot of people were without power. That's not his fault, but it was a thing. If the roof was damaged and there should be some abatement, all right, we can discuss that. But at this point, it appears you owe 2 months rent, and you're about to owe 3 months rent. So add $1,500 and another late fee when we get to our next hearing, because the rent will be due on September 1st. So if you do plan to move, let me give you a heads up. When we meet next, which will be next Friday, September 4th, you're going to have 10 days from that day to move out or be subject to being evicted.
Okay, we're looking for a place. I do have money, but I just need to know where I can go to pay it because his stipulations are to only deliver it to his house, and it's his pole barn outside of his property.
Can I also put one thing in, sir?
Yes.
We're also paying on 2 meters of electricity for one building.
All right, I'm going to continue this to September 4th, 2026 at 1:35. Now, my suggestion is you hold on to your money to use it for first month's rent and security deposit in the next place you're going to move to. If you intend to stay there, you can pay the rent and continue with your residency. But you may have some issue now. All right, here's the deal. I'm gonna talk about this again with you next Friday at 1:35 in the afternoon. I will give you at that point 10 days to move or be subject to being evicted unless you pay the rent.
Oh, okay, regardless, I'm gonna pay it until something comes up because this place is a lot more expensive than we anticipated, because even when I got the electric hooked up, we have to pay on 2 meters and we're paying for the building to even have power outside in the hallway and everything, and my electric has been $500 a month.
All right, well, let's talk about that. You've indicated there's 2 electric meters. So you're paying electric for your unit and other electric for the building?
Yes. And he did not notify us that until when I did hook up the electric. Then I had to call the electric company because the other half of the apartment didn't have electric, or the apartment building out in the hallway. So I called them and they were like, oh, this apartment has 2 meters And I notified Seth and he acted like he never knew anything about it, which he would know that because he's had prior tenants here. So it's costing me $500 a month just in electricity just for this apartment.
All right, well, we'll talk about it further on next Friday.
Okay.
I'm not sure the city inspector would allow that, but also this collapsed ceiling may be something that would need to meet code.
Yeah,
At
there's
least as code enforcement. That's awfully expensive. How big is this apartment? About 1,200 square feet?
It's about 2 apartment complex.
It's 2 apartments in one. He made it into one big apartment.
All right. Well, I've been in a number of those apartments above the store. Some of them are quite nice. I don't know if I've
This
ever
one
been
is
in this
not.
one. All right, well, then you may consider moving somewhere else.
Oh, I
or
am.
paying
Yeah.
rent. So when I see you next time, assume we're gonna add $1,550 to the amount.
Okay.
So, 3312.12 plus 1500 plus 50 is 4,862.12 through September.
Well, I just
So-
started doing home health care and I'm making better money, so there won't be a problem paying him the money, but moving forward, we are in the process of looking for something different.
All right. Your lease began February 14th of 26, and it expires February 28th of 27. So if you leave before your lease is up, you could be subject to unpaid rent if he's unable to lease the place for a couple months. The lease binds the landlord, it also binds the tenant. So your lease is up February 28th of 2027. Maybe you can use that as a target date to get a new place.
Well,
At
he
any rate-
did send a text and said that if we moved out before, that he would not penalize us for it.
Well, he could certainly agree to do that. All right, well, let's talk about this next week, September 4th at 1:35.
Okay,
You're free to. All right, thank you.
thank you.
Mr. Thorpe, you have any questions?
No, it was a
All
ceiling.
right, well,
It wasn't a ceiling tile,
it was a what?
just a ceiling tile, you know, the little square ceiling tiles. It wasn't the
All
whole
right.
ceiling. And the 2 meters, 4-bedroom, 2-bath apartment, Main Street Cafe, is where the light bulb in the hallway.
No, because I actually had my electric disconnected the other day because I didn't pay it, and the whole hallway light was out during that period. It does not work unless I pay for it.
All right, we may explore that further.
Okay.
All right.
I have pictures and everything of the ceiling too. It wasn't just one ceiling tile.
All right, bring it with you.
Okay.
Thank you.
Thank you.
All right. We have a 9:35. And then we have 2 10 o'clock general civil matters. But let's take up Riverside Townhouses versus Childers. I don't see anybody here on that case.
Mr. Hall,
Say that again.
Mr. Hall,
Oh, yes. All right. Riverside Childers and Hall. Andrew Rognus is here for Riverside Estates. Mr. Hall is here. I've also got somebody by telephone. Who's the phone number that ends in 9103?
That is, Joel Eichhorn, Your Honor. With it,
Say that again.
James Soames. It's Joel Eichhorn, Your Honor, with James Soames.
All right.
And I am here if you can hear me, Your Honor. James
All
Soames.
right. Okay, I'll be with you in just a minute.
Okay.
Let's take up Riverside Estates, which is a pretty glorious name for what it actually is, but versus Kayla Childers and Nathaniel Hall. I see Scott Hall is here.
Moving out last time, Your Honor. I think they did till the 7th, if that's correct. Scott? Scott, you there still?
Boy, I'm having trouble with my audio today. Scott Hall, are you connected to Riverside versus Kayla and Nathaniel Hall?
That's Nathaniel.
All right, Nathaniel, he was here last week. He indicated he wants to move. Mr. Hall, what's your position?
We're still waiting for them to finish their inspections. They are to the point where it's gone to HUD now, I believe is what they've told me. So we're still hoping for at least the first. This is definitely something we don't want to be in anymore.
Well, you have 10 days from the date to move, which would be September 7th. Now, did you say Miss Childers is no longer there?
No, she's just not here with me today because I came in from work.
But she still lives there.
Correct.
Well, she has the same obligation.
Correct.
All right, you have until September 7th to vacate or subject to being evicted. They don't have to evict you on September 7th. They have 56 days from the day to do it. But you also have till September 7th to appeal this. It sounds like you plan to move. No money judgment is entered at this time. When you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
I'll give you the same advice I give everyone. Stay in contact with your manager and let them know what your intentions are. But at this point, under the law, you have 10 days to move or you're subject to being evicted. They can give you more time if they wish to, but they do not have to. So it's important you stay in contact with the manager and let them know what your plan is. But I understand why you'd want to leave here. All right, do you have any questions?
I'm okay, Your Honor.
All right, you're good to go. Thank you.
Thank you.
Thank you, Mr. Agnes.
Your Honor,
Yes? All right, we have Eichhorn and Soames, which is set for 9:40. I don't see Mr. Eichhoff.
Mr. Eichhorn, Your Honor.
Mr. Eichhorn, yes.
I'm on the phone, Your Honor.
All right, are you James Eichhorn?
Oh,
No,
Joel
I'm James
Eichhorn.
Soames, and
Yes, I see you, Mr. Soames. I don't see your landlord.
I'm on the phone, Your Honor.
All right, what's your name?
Joel, Joel, Eichhorn, Eichhorn.
All right, well, I gave you the wrong name because I couldn't figure out what you were talking about, and I don't like doing this by telephone only, particularly if you're the landlord. You ought to know how to do this. Tenant is here.
I apologize, Your Honor.
All right, this is not very artful.
Hmm.
All right, let me make some notes. Let me do this here by telephone only.
Your Honor,
Yes.
I did want to be on video, but I had some extenuating, like, circumstances this morning.
All right. This is filed as a demand for non-payment of rent. This is a property at Nottawa Street in Sturgis. There is a lease, $550 per month. What is the current arrearage?
Your Honor, the rent arrearage is $1,340. That includes a partial for June, a total for July, and total for August.
All right, that's what it was at the time of filing. Court costs are $55 filing and $57.90.
Today.
Go ahead.
First one is, defendant's motion to compel disclosure of the state's method of authentication, admission, and sponsorship of electronic evidence.
I think, Judge, I can, in short, the state will follow the rules of evidence and the code of criminal procedure in offering or authenticating any evidence that we offer at trial.
Your Honor, this case is going on, I think, 2.5 years now. This is a
If we were the only one,
or 7th trial setting.
if they're the only one,
In the 2.5 years, Your Honor, this is the entire notebook binder that I have. And
Okay.
none of my motions have ever been answered by the state. I didn't even know who, with requests for, discovery or anything of that nature.
have y'all met?
I have not met Mr. This new
Coleman,
I'm
Judge,
sorry.
I just inherited this case, as the court's well aware, from the third prosecutor case. I am happy to comply with all of our obligations under the 39
He's a good man.
of the code of criminal
I have
procedure.
no doubt.
Brady
Once I
Act.
get with,
Happy to do it all.
get together, I think he
I have no doubt. he's a great
he will,
man.
I think he can expedite whatever you need. But, yeah, I just finished my 620th felony jury trial preside. Nobody's done that. So
Yes.
we're not hesitant to try cases in this room.
I understand.
And just whatever y'all need to prepare, get it done and we'll move
I'll
forward.
make it happen, Judge.
What do you need today, sir? Yeah, what can I do?
Well, as I also filed some motions in limine, I believe we can address those on the day of trial.
Thank you. Yeah, yeah.
And
These things evolve and sometimes a decision now gets changed as it gets right at trial. What,
there's also a motion to quash the indictment. I don't know if you want to hear that now or on the day.
go ahead, summarize what you contend is a problem.
Yeah, Your Honor, we allege that the indictment fails to put forth any manner in which the complainant was harmed. I believe that we need adequate notice so that we can, adequately prepare for our defense. The indictment fails to mention how the complainant was harmed, if at all. And so in order for me to be able to prepare a defense, I need to know how she was harmed.
Your Honor, the state's indictment tracks the statute, and the indictment is intended, as I understand the case law, to just simply provide notice to the defense counsel of the nature of the allegations. And lastly, Judge, I'm not aware of any case law or any authority that requires us, at least at the pretrial stage, to demonstrate the nature of the harm to the complainant.
Well, how can I prepare a defense if I don't know what?
Okay. Are you saying that this indictment does not set forth the elements of the crime under section 42.072 of the Texas Penal Code?
Yes, Your Honor. If we
What
can-
does it fail to say that's in the statute?
Let me pull up the indictment if I can find it.
I've got it here. You want to look at it?
You cited 40, chapter 42. That's with regard to
Section 42.
Section 42. Thank you, Judge. Just with regard to the stalking. We also have the companion case of publishing or threatening to publish intimate material. Just for the record, that's under chapter 21.
I'm just looking at the stalking right now.
Yes.
That's-
Your Honor, the one, just for the record, the one that's being tried on the 14th is not the stalking, it's the publishing.
Judge, the state gets to elect which one we try.
So,
And I haven't made. the election.
Wait.
Your Honor,
You're right about that, but what are we going on? Which one are y'all gonna go on?
Judge, I just literally looked at this case yesterday and I'll figure that out. today.
Your Honor, these are already decisions that were made way prior to Mr. Coleman coming onto the case.
I'm not bound by the decision of a prior prosecutor as to which case to go forward on.
And Your Honor, just for the record,
As
my entire preparation for trial has been on the publishing case, not on the stalking, because of the fact that we were told on previous court settings that the one that was going to be tried was the publishing case and not the stalking case.
Your Honor, they arise out of the same criminal occurrence.
Okay, all right. Anything else from anybody?
That's it.
Okay. Which one is the state intending to try first? With this prosecutor? Yes?
Give me a second, Judge, please.
Yeah.
And Your Honor, one of the,
Judge, here's what I intend to do. I intend to file a motion to consolidate these cases and try them at the same time. He certainly can file a motion to object and make his argument to the court. These arise out of the same criminal episode, and as such, we're entitled to consolidate them.
Okay, in all fairness to him, that you told him that.
Judge, I just looked at, I got his motions yesterday. I just looked at the case yesterday.
yeah, these motions have been filed for quite some time.
Judge, you understand the turnover in this court, and I'm drinking water from a fire hose to get caught up on the docket, Judge.
All right.
And Your Honor, one of
In
the-
all fairness, they, and it's not him, I mean, his boss makes changes and there's a new prosecutor in town on this.
yes, sir.
So in all fairness, they get an opportunity to prepare, but you gotta move forward. And the statements that the defendant was told on behalf of the district attorney's office that he relied on, in all fairness to him, he spends his time focusing on that. And when it's changed and a prosecutor gets to make an independent decision that's different from what had been told previously, then he has a fair opportunity to get ready for this. But everybody remember, this thing's 3 years old and moving past 3 years old. And we try cases here, but what is it going to take to get ready for this? And also, is that what you're telling the defense, that you're going to consolidate? You want to try both
That's
of
what
them?
I'm representing to the court and
All right.
against counsel. I will file a motion to consolidate as expeditiously as I can.
Okay,
That is my
he gets a
intent.
chance to be heard on.
And Judge, I'm sorry to interrupt the court, but
Yeah.
one final thing. These are all out of the same transaction. He can't argue unfair surprise. Oh, I didn't know that this
Well,
would become an issue.
Well, hold on.
It's out of the
He
same
can argue
transaction.
whatever he, in good faith, feels like he needs to
I beg to
represent his client.
Your Honor, I can't argue.
I've never
unfair
heard
surprise.
that from a defense attorney. I beg to differ from the prosecutor. Look, here's, as amusing as this is turning into, let's move forward.
Yes, sir.
What is it we need, that you need from me, so we can get this thing to trial?
The state will be ready.
And, yeah, again, we've done 620 trials here. Nobody's ever known to do such a thing. We try cases here. So it's not me that's the problem. What is it y'all need to do to get ready?
The state will be ready on September 14th to bring this case before jury.
Okay, but you want to consolidate. He's going to get a chance to be heard to how that plays out. And he also said that he was told by a previous prosecutor that it would be going one way. And so in all fairness to him, he has a fair opportunity to redirect his focus in light of the new prosecution, which he's entitled to
I
pay.
understand, Your Honor, but in my defense, I would just like the court to know that I haven't even begun preparing to trial for a stalking.
What do you need from me? What are you asking for today?
Well, I'm gonna need it, some additional time.
All right, you got it. You got it.
Judge.
Yes.
I don't,
Ma'am,
you special set these cases on September 14th. I can people.
I know it, but we got an issue that's come up since then.
And Your Honor, I'm not sure when it actually happened. The lead investigator in these cases was
Yours or the state's?
in the States. The lead investigator was tragically killed in an accident, as you, I'm sure, are well aware of.
Okay, and so
What?
what?
It was her investigation. It was her evidence.
Okay.
It was
So-
her testimony that was going to be up for cross-examination.
Oh, okay, well, I mean, okay, so
That's our issue, Judge, and we'll work within the rules
States-
of evidence.
we'll see
and
what
the code of
happens.
criminal procedure to make sure that we get whatever evidence we need to get in.
I was on the committee that wrote the rules of evidence. I think I can.
Yes, sir.
What do we want to do today?
Well, I wanted you to make some findings on motions that were brought up to the court.
Okay, the motions being what?
On the motion to quash.
Denied. The court's read it, then the court is satisfied. It sets forth the elements of the statute in the allegation. But I want to make sure that you've got all the discovery you need for preparation.
Yes, sir.
What else?
And on the motion to compel,
Compel.
on the motion to compel the disclosure of the state's method of authentication and making that sponsorship.
I'll disclose that right now, Judge. We will follow the rules of evidence and the code of criminal procedure.
Well,
That's our method.
okay, he's I guess he's asking for how that's going to be done. And what do you say to that?
I say if it's photos, we will follow the rules of evidence that pertain to authenticating photos. If it's videos, we will follow the rules of evidence as it pertains to the authentication of video.
Okay, depending upon what it is, give him a fair opportunity to know what it is so that he can prepare any objections if he needs to. Let's don't surprise during the middle of the trial, so we have to stop and everybody go and start over for prep.
Yes.
I don't want to do that. When we start, let's move forward from the beginning to the end without delay.
Yes.
And what else?
Well, the other motions were going to be taken up at front.
Okay. All right. All right. So what are you asking for the next event now?
Right now, I just need time to prepare because now he's going to throw in the stalking.
How much? Okay, I'm going to reset this for a review. How much is 4 weeks going to be good?
That puts us in October. Yes, sir.
Okay, 4 weeks.
Thanks, Judge.
Correct.
Yeah, it's going to have to be pushed off, and we'll have something else special said.
Your Honor, and I apologize for, but I just need to be able to adequately prepare.
Yes, sir. Okay. All right, just let's get it done so we can move forward.
Yes, sir.
We often use a relief after 3 years. Mhm. Am I on the bond forfeiture docket?
Yeah.
All right, in the matter of Leanna Wilson.
Pardon, Your Honor. No, right quick. We're trying to get a second. Your Honor, I think we can make this bond forfeiture docket a little quicker. Yeah.
Well, that would be a nice thing.
I'll just run it by you real quick.
Yes, sir.
The state would request that the court take judicial notice of the court's bond forfeiture docket.
It does.
And the state would request that the court take judicial notice of the underlying criminal case and of the Judge McNally case for each of those identified matters on the bond forfeiture.
Yeah.
All right. And Your Honor, we would ask that the court enter judgment according to the court's docket. And we have written judgments for that as well.
Stand on. Lacey. Where?
There are no files, Judge. Those are just bond forfeitures. These are for this is for the regular docket.
Yeah, there's no file on it, Your Honor. We don't bring in the file.
This is for it's probably on your desk, Judge. and we'll grab it. The regular, you're not gonna have files for the bond forfeiture docket. Those are just bond forfeitures.
I kind of picked it up. These are the only ones that were on the desk.
On your desk.
Okay, back to the bond forfeiture, Leanna Wilson.
And or for all of them, Your Honor, we have prepared written.
Stand by.
Judge, I'm gonna have to, this is one of my clients, I'm gonna have to object to failure to give you notice on this hearing.
This is a Judge McNally case. This is not.
I need to have some
You're not
idea.
her attorney. You're
I
not
am
her-
her attorney.
It's not in the Judge McNally case.
This case, but you have it,
This
you
is,
have.
this is the Nisi case.
Okay.
The 26 DCCP 0197 is the Nisi case.
Is the court going to appoint me on these other cases, Judge?
You don't get appointed for.
I'm just
this
thinking, I'm just
this
making
is
sure.
Civil.
Okay, I'm just checking, make sure.
Okay, this is civil
Just
proceeding.
making sure that when you talk about my clients, I want to make sure I'm
Okay,
on top of it. Thank you.
yep.
Go ahead.
All right, Your
Where
Honor,
were we?
we would ask that the court enter judgment according to the court's bond forfeiture docket.
Okay, we're on 26
I,
CV 197, and are you asking for all of these? On
yes,
This
blanket
is
entry
in
and
3
then
pages.
blanket entry and then signing of the written
There's 10
judgments.
matters, 10
Yes.
separate matters.
Yes, Your Honor.
Go ahead.
And here's the judgment for the court to enter. Those are all prepared according to the docket.
The first one is Robert Glasper. My first case is Leanna
So
Wilson.
we have them out of order. So,
Would you do shuffle the deck?
Sandra. Do we have Robert?
You can leave now there, Brent.
Yeah.
Kind of a slap in the face there.
Where is it? Oh, it's on the second page. Your Honor, let me reorder those if over.
All right, I've got Leanna Wilson here. Go ahead on 26 CV.
We would ask,
197.
we'd ask that the court sign that judgment, Your Honor.
And any other
Okay.
summary on this?
Oh, yes, on this one, Your Honor, it's basically court cost of $358, interest of $90.41.
All right, in those amounts, the court renders a final judgment in this criminal case 26 CV 197. The defendant is Leanna Wilson. Shirley was Al Reed bail bonds, and the relief is granted as requested by the state in that case.
All right, thank you, Your Honor.
I have next is Joey Childress,
Okay.
cause number 25 CR 314.
And Your Honor, this case is for court costs and interest like the last one. Mr. Childress was rearrested, so the bondsman, Lisa Martin, is only responsible for court costs and interest.
Okay, so that $15,000 bond is not going to be
Correct.
assessed against the
Lisa Martin.
Lisa Martin in this case.
That's
Okay, you're
correct.
just asking, it's at $44.38?
Oh, well, it's $358 for the court costs and then $44.38
Okay, and
for the
that's-
interest.
For those amounts, the sum total of those amounts, you were requesting this final judgment be rendered,
Correct, Your Honor.
and this court finds good cause and proof to support the request of the state, and their relief in this case is hereby granted. And judgment is signed on this date, August 28th. Next
It looks
is
like,
Tommy Beecham.
yes, Your Honor. Again, court costs and interest on this case because Mr. Beecham was rearrested.
Okay. For those limited amounts, it looks like the amounts are how much now?
Court costs are $358 and the interest is $27.62.
For the sum of those totals, the court is rendering a final judgment as requested by the state, signing this on this date, August 28th.
Yeah, Mr. Beecham.
26.
Mr. Beecham was arrested in Orange County, but Orange County dropped him off at Jefferson County, so there was no extradition charges, Your Honor.
Yeah, they find that amusing somehow.
Yeah.
Okay, 26. I'm sorry, clause number 23 CR 2000, which is Facius, Skylar Facius 26 CV 272, the state of Texas versus Cameron Smith.
Again, Your Honor, this is another court cost for $358, interest for $53.42, and this one has a transfer fee of $130.65.
For those two amounts, sum total, you're asking for relief?
Yes, Your Honor.
And that is granted by this judgment the court is signing as the court finds that is supported. Transfer fees in the amount of $130.65 and a judgment NESI interest in the amount of $53.42. The sum total is placed into this final judgment. The relief requested by the state is hereby granted. In that case, next.
The next one, Your Honor, is Cameron Smith, cause number 26 DCCB 0274.
Well, that's
that's
the underlying class
a related case.
CR 2001. Yeah,
right. That's a related case again. But it is a separate charge, separate case. So there's a separate bond on it.
Yeah, we're going to call it the Skylar Facius number.
Okay.
SCIR FACIAS. Go ahead.
Yes, and anyway, so he has a second one, two charges on him, and the transfer fee was added to the companion case, so he doesn't get double dipped on that. So the state is asking for court costs and interest only in this case.
All right, and the total amount is
well, it's a little over $400.
Okay. Which includes the
court cost,
$53.42 cost of court.
Yes, Your Honor, or the interest. That's $53.42 is the interest. The court cost is $358.
Interest from the date of judgment NESI to the date of the arrest.
Correct.
Okay, well, the relief requested in this case, which is underlying cause number 23 CR 2001, the state of Texas versus Cameron Smith, as requested by the state, is hereby granted on this date. Next, we have the state of Texas versus Laurelyn Marie Gocher.
Okay, Your Honor, on that particular case, there's court costs
down here.
I thought you had two. There should have been two, Your Honor. Yes, two.
Yeah, sign both of those.
Yes.
Go ahead.
Okay, on Gocher, Your Honor, again, court cost of $358, interest of $67.40, and a transfer fee of $374.10.
All right, the relief requested by the state is hereby granted in those amounts, and the court is signing a final judgment in this case involving Laurelyn Marie Gocher in the amounts the state has requested. I've signed a final judgment. Next is the state of Texas versus April Morales.
Your Honor, in this particular case, the state is requesting again the court cost of $358 and interest in the amount of $48. Ms. Morales was rearrested. Well, I guess it took a little while to get her back.
A little while.
Yeah.
All right. Again, the total amounts and identified in each amount. I've got $48 in interest. And the other amount is
358. And we put those in there as to be calculated by the clerk of the court, because if there's any additional court cost added after the judgment is entered, say for the mailing of a certified judgment, all of those court costs get added on at the end, Your Honor. So that's why we don't put a specific number in there.
all right. In this cause number 25 CR 747, it's against Gary Facius, number 26 CV 281, the state of Texas versus April Morales. The amounts of the relief requested by the state are hereby granted. The court has signed a final judgment on that case. I have Corlina Solomon.
Your Honor, on this case, again, it'll be the court cost plus interest. The interest in this case is $542 and 47 cents.
Court finds that the requested relief is granted. A final judgment is rendered, and interest looks like it's a high amount, in the amount of $542.47, along with the other amount requested by the state, which is how much?
Your Honor, that's currently the filing fee is $358. So that's the court cost.
So in those amounts, the sum total requested by the state is hereby granted. The final judgment is hereby signed in that case. I've got Audie Joe Santana.
This case, Your Honor, the state seeks court cost of the filing fee of $358, interest of $61.64, and a extradition charge of $130.65.
Where was that from?
I don't know off the top of my head. We can figure that out for you, Your Honor.
The relief requested in cause number 25 CR 821, Scary Facius, number 26 CV 721, the state of Texas versus Audie Joe Santana. The relief request is hereby granted. The final judgment is signed in that particular case as requested by the state. Robert Earl Glasper.
Your Honor, on this case, it's court cost of $358 and then the interest of $55.23.
And the relief requested in this cause number 24 CR 1032, Scary Facius, number 26 CV 251, state of Texas versus Robert Earl Glasper. Request of relief by the state is hereby granted. A final judgment is signed in that matter.
And that is the last one, Your Honor. May I be excused?
May.
Thank you very much, Your
Thank
Honor.
you. Here are the judgments. Devon Sampson. Or Devon.
How you doing? Good morning, Judge. Good morning. Thanks. Good morning. This is a 3-month review to check his status, and my understanding is, from talking to probation, he's doing well. As far as the review today, I think it was a 3-month review. And he is gainfully employed, right? All right. Sorry about that. I was leaving. And I did talk to the probation officer, and she's fine with continuing him on supervision.
Shuffle the deck. Somebody shuffle the deck.
That's all I've been coming to this. Okay, I don't need that.
And cause number 21-37762 is called State of Texas versus Devon Alexander Sampson, the defendant. There's a pending motion to revoke unadjudicated probation, right? on this?
It is just, I believe the court held it in abeyance at some point, according to my notes.
I didn't make any, well, the motion was, listen. Motion to revoke held in abeyance. It says 3 months.
Right.
On 6/1/26, but the court did not make any findings on this. We just must have held it.
Cause y'all wanted to see how well he was gonna do. And what,
But see, I didn't, we must not have had a hearing because I didn't write on this, of him making pleas.
I don't think so.
And it's,
I don't
so
think it was.
we didn't have a hearing on him entering pleas in the matter. So there must have been something else that caused the court to postpone it. Was it preparation or something for you?
I think,
What happened was he committed a new offense and he was.
When?
25.
October 2025.
Okay, that's different from these 4 allegations here in this motion.
So this was one of the allegations.
That's one of
No, it's not, because, okay, allegation 1 states he committed the offense of criminal mischief on or about October 2nd, 2025. Number 2 says failed to avoid injurious or vicious habits. 3, failed to immediately report community supervisor the arrest. And 4, failing to pay fees. So the only crime charged is a October 2nd, 2025 Class A misdemeanor for criminal mischief.
Yes, sir, that's it.
I didn't make any findings on it because I didn't write anything on it. So let's see. MTRP status hearing. On August. This is August 24th. Was that 4 days ago? We were here? Couldn't it be?
no, no,
No, sir.
no, it's been a while since we've been on him.
Yes, that's correct.
And like I said,
Looking at-
understanding, you just wanted to see how well he was doing.
Okay.
And she was gonna tell if he was doing right, and I think she's saying
Okay.
is he doing good?
I had an order, I signed an order amending the conditions of probation.
Check the stats.
Been signed August 24th, 26th. That's weird. Which would have been 4 days ago.
Yes, sir. But no, this wasn't no kind of a hearing or anything like that.
Okay, when does it show amended? I
That
signed
would have
it.
been to prioritize his restitution because he does owe restitution.
When would I have signed? Is this the correct date of the order amending conditions of probation? So
Yes,
that was 4 days ago.
yes.
Oh, okay, okay. All right.
So we all good.
Oh, so that's
Right.
here today, MTRP status hearing on the docket. What is our status for
There
this
you go.
motion to revoke unadjudicated probation that is pending?
That's-
It was filed in April, so
He's doing well. He's reporting as directed.
what's the state asking? Are we just not moving forward on this, waiting to see how he does?
Judge, I understand this is, to agree with Mr. Adams, I can't believe I'm saying this. I thought this was a status hearing, and I visited with the probation department, and she's saying that the
We
status.
don't- okay.
Yeah, I thought we was.
The motion was filed in April. What do y'all want to do with it?
Oh, Judge, with the court's permission,
Yeah,
I'd like to withdraw the motion, Judge. I'll dismiss the motion. Under these circumstances, given
Okay.
the
All right. Send me
representation
in.
of the probation department that
send me a
he's,
dismissal
he's-
and
he's
we'll discuss
compliant.
that.
Yes,
So
sir.
we're just
Thank you.
from
Thank you.
probation, we just continue him. He's on probation until 27.
Yes, sir.
And what do we want to do from probation today?
We want to continue him on probation.
Okay,
Thank you, Judge. Appreciate it.
that other
Thank
thing
you,
will be
Mr. Goldman.
dismissed.
Y'all take it easy. You good? Just keep doing right. Stay out trouble. Thank you. I got it. Okay, I do that right now. Thank you, Judge.
Okay, on Christopher Smith, Is this true? The federal government
Yes, Judge.
got him?
Yes, Judge.
So he's not
He's
in town.
No,
And what do we do on this case today?
I believe, Ellie usually puts them on their own federal based docket to check and make sure that they're still in Fed custody. And then
What's
once
the
they're
word on
back
it?
to
You
us,
know,
he just had his arraignment this past week, Judge. So
in
he,
Feds?
yes,
Okay,
His-
what's he charged with there?
same thing.
Child pornography?
Yes, Judge. His timeline with the feds just started this week, so I expect.
Well, where's the state on this? Yeah, are y'all just holding this to see what the feds are going to do? And is this an overlapping set of facts, or is this a different set of facts from what the feds had on them?
It is overlapping, Judge,
Okay.
and we are speaking and in communication with them to see how we're
You know
going to
where
proceed.
when there might be a disposition in the feds, we don't know.
No,
yet.
I think arraignment was just,
It was on something like that. They're not going, I don't think probation's in the
no, I
in the
agree.
mix for them.
Not at all.
With the feds is anywhere from 15 to 40, I believe.
And probation
Just
is not on the
statutorily.
table for us either.
15 to 40 years.
I believe, yes, Judge. At least with the guideline calculations.
The
and-
parole stinks in the feds, you know that. You don't get, you do that time. So what do we do with this? Just kind of hold it and review it in a few months to see where the federal government is on
Yes,
it?
sir. Yes,
That shall be done.
Thank you.
That's all.
Yes.
Christopher Smith, cause number 26 CR 662. Why don't we review this in 3 months? Okay. Randy James. It's Johnson. I just wanted to see if you knew I was going to change his name. All right, there is a first amended motion to revoke unadjudicated probation in 23 CR 1233, the state of Texas versus Randy James Johnson. That's you? Yes. Let's see. Theft. DWI. Failure to report. And there's a first amended resisting arrest. Kidding me here. It's a different date. Public intoxication. On my watch, you're alleged to have committed two different sets of crimes on 2 separate dates. Notwithstanding the other 9 allegations of violations. Okay, this was filed in February. Are we ready for a hearing?
No, Judge.
Judge, we have fashioned a deal that will ultimately resolve this motion. to
Maybe.
remove probation.
Let me hear it since I get to decide.
For the resisting arrest from December of 2025, there is going to be a 30-day jail sanction added to that. And then once he has done his jail sanction, then he will be reinstated, or the motion to revoke probation will be dismissed moving forward.
That's correct, Judge. And I've just visited with the probation department about that, and I think she has maybe some additional things she'd want to amend his probation conditions to include as a result.
I'm anxious because there are 11 violations. Are you kidding me? We made a big deal. 11 violations are alleged and crimes, 2 crimes.
I think Ms. Manali.
Hold on, let me speak.
Yes, sir.
Please,
Yes.
thank you. So y'all can just deal with what I'm concerned about. This never happened. You don't get 11 violations and then sashay out of here. What's going on?
I think Ms. Minaldi can speak to the fact that it was originally those initial allegations were dealt with in a previous proceeding.
That's correct, Judge.
And then there were 2 other, the misdemeanor resisting.
So 1 through 6 are from a first motion to revoke probation that was filed,
7 through 11,
and then 7 through 11 is a subsequent.
which includes another crime.
I understand, Judge.
But those initial ones, they were dealt with, they were
They were done.
adjudicated.
So we're only here on 7 through.
They were adjudicated, Judge, right?
Who?
I mean, didn't we?
We resolved those.
We did 1 through 6. That's all we did.
1 through 6, we resolved with.
We only had 1 through 6 dealt with there, and then thereafter, first amended motion rolls over and we haven't had a hearing on that, which was 7, 8, 9, 10, 11, including a resisting arrest on December 12th, 2025.
And just to be clear, I think, I just want to make sure.
Hold on, let me look at something.
Yes, sir.
Yeah. We, because this isn't clear to me, and y'all have to make it clear because this doesn't make sense. We had a hearing.
That's right.
On June of last year.
Yes, sir.
And June 4th, and he admitted to committing a crime, driving while intoxicated. And this was, there were other miscellaneous violations that were not substantive crimes, but were other conditions of probation that were allegedly violated. But he pleaded true to the driving while intoxicated while on probation. And we resolved that on June 4th, 2025.
That's right.
This first amendment comes up. It alleges that 5 or 6 months after that hearing, it's alleged that he committed the offense of resisting arrest. Okay, how many chances do we get here?
And we're thinking that we're thinking the appropriate sanction would be 30 days, sitting 30 days in jail on essentially a misdemeanor resisting, which is what he would get in all likelihood if it was a standalone misdemeanor offense, and then continuing on probation. At least that's our calculation, our thinking, Judge.
And then that would dismiss the motion to revoke probation after the resisting arrest was handled.
Judge probation just made a great point, and I'd like to share that with the court, please.
Yes, Judge. In reviewing his file and his financial obligations, he is making payments to restitution. He has a balance of $680 left. So
to revoke
to the victim.
Meanwhile, he's committing crimes.
Yeah,
I understand, Judge.
You don't buy your way out of trouble,
And it is.
do you? Oh, no. Let's just think of what we're doing here. We sent a message. Now, what's good, everybody else who's on the motion to revoke docket is going to walk up and say, I want the Randy Johnson job. Well, I can commit a couple more crimes here and I can sashay out of here.
30 days.
What's fair is fair.
30 days in jail, Judge. We're not just cutting him loose completely. But I get where the court's coming from.
And we are moving cases as well, Judge. And I get where support is coming from on that end too, but
The first condition of probation in every probation order, do not commit a crime. He's committed 2 now since we put him on probation. And so we let him walk out of here.
With 30 days as a sanction.
He's on probation for a state jail felony. That's what the violation here. They've got the misdemeanor in another court. That's not what I'm worried about. I'm worried about violations of probation. That you made promises. Okay, let me go. Okay, begins with at 10:36 p.m. There's got to be a curfew violation here, right? He's supposed to be at home. Yeah, from 10 p.m. to 6 a.m. So he's out on the road at 10:36. Busted that one.
are we talking about violation number?
The
2?
December 12th, 25. I'm looking at the probable cause.
Oh,
Police go to Killarney Drive. The vehicle, while en route, police are advised the vehicle is running, parked on the wrong side of the road, and the driver is passed out at the wheel. On arrival, let's see, EMS advised, keys to the vehicle. We're on the hood of the vehicle. I observed the vehicle was not running. I observed officer speaking to Randy Johnson, sitting in the drive-in. Multiple verbal commands were made for Johnson to get out of the vehicle, in which he failed to comply. I detained Johnson in handcuffs and appeared to have slurred speech and bloodshot eyes, unsteady on his feet, failing to comply with simple commands. It is my belief Johnson was intoxicated on something. Due to the fact he was obviously intoxicated in a public place with no responsible person to take care of him in the middle of a public roadway, it was my belief he was in danger to himself and others. I placed him under arrest for public intoxication, secured him in the patrol unit. Johnson was then transferred to my patrol unit. I transported Johnson to the jail. On arrival, he was asked multiple times to step out, in which he refused out of the vehicle. I attempted multiple times to assist him out of the vehicle, and he was resisting me. He was not, and he stated he wasn't getting out of the patrol unit until somebody else came. After a brief struggle, I was able to use my physical strength and agility by grabbing him by his upper body, assisting him out of the patrol unit. He was then assisted inside the jail and booked. Okay. Go ahead.
Well,
Go
that's
ahead.
that's not where we are, Judge. We understand the court's concerns and hesitancy in adopting or accepting our agreement. But that is our agreement in the court. You understand your authority. You're free to reject our agreement.
Yes, I am, and that's not going to do it. Now, there are ways of handling this, but this isn't the way I want to see my probations done. You can't be placed on probation, make a promise, and then commit 2 more crimes while on probation, and then say, let's just pick up where we left off. I'll go to jail for a few days. No, that's not the way it works. Y'all got to figure something else, or else I'll do it.
Understood, Judge.
What I'm going to do is reset this for 2 weeks. Y'all review it, y'all decide. But somebody on deferred or unadjudicated probation gets arrested on 2 separate crimes. If those are valid arrests, then they're not going to stay on deferred. Catch my drift.
Yes, Judge.
Okay,
Yes,
2 weeks.
Thank you.
Sarah Burnett. What are we doing here?
Status hearing, Judge. Status hearings. Just checking in.
Okay. Well, all right. What we have are 2 cases where the defendant is on probation for, and one's a theft, the other's a theft. And 13-17581 and 15-21605. There are first amended motions to revoke probation filed in each case, which are 1.5 years old. And they allege similarly, the defendant is behind on tons of money, fees and costs and restitution, I guess. And meanwhile is showing positive for marijuana in her system back in August 2 years ago.
Oh,
okay.
Yes, sir.
Where are we on all of this?
Judge, she is making all of her payments are going to restitution.
How much?
As of
Or
right now,
is she paying per month?
well, she was, I believe, at one point, supposed to be, what, 800? Yeah. She is working
How much is she paying a month now?
what she can.
What-
But she
what
is
was-
making payments.
What was the last payment of the last month?
Okay.
Okay.
On cause number 15-21605. Her last payment was April 29th of 26 in the amount of $41.
Hold on, that was 4 months ago?
Correct. But she does have a lot of restitution on the other case. That stuff is being split on there as well. On the (13-17581), restitution is owed there, and she paid her last payment on this one was on May 21st, 2026, in amount of $62.
3 months ago.
Yes, sir.
How much?
62.
$62.
Yes, sir. But I do want to say, the MTRP was followed just to keep the case open to allow her to continue making payments towards her restitution. At this time,
Meanwhile, she's showing up with drugs in her system,
Judge.
right?
How long ago was that? 2 years ago. 2 years ago.
How's that happened since 2 years? She's been clear?
Yes.
Is she getting drug tested every time?
The MTRP's,
Is she getting drug tested every time she comes in?
yes. But the total amount for her restitutions that she's paid in since all restitution has been, all her payments been going to restitution has been $7,855. The total amount left for both restitutions added together is unfortunately $134,625.15.
Yeah, well, it started out 130, it started out at 142,000.
Yes, sir.
So if she's been on probation, what?
She's over
12 years.
Yes, sir.
And we've got a grand total of 12,000. Restitute?
Yeah.
And so 142,000 to begin with.
Yes, sir.
And now it's down to 134,000?
Yes, sir.
Okay. So that's,
$134,625.15.
so that's, she's paid $8,000 since being placed on probation, which was 12 years ago. That's right. Would you say?
I have no reason to disagree with that, Judge.
And Judge, the payments are making it to the victims of the offense for both of them. They are receiving their payments.
Okay, thank you. Is this like an extra copy? Yeah.
Oh, what does anybody want to say on this?
Judge, I would like to continue with the MTRP and allow her to keep making payments towards her restitution and do a case review within 6 months to see where she's at. If she could possibly pay more than she will. That's where I stand with.
She's been on probation for, what did we say, 12 years now? So we've got a track record over 12 years of, at this rate. How long would it, do you know how long it would take you to pay off this restitution at the rate you've been paying for 12 years? 200 years. 200 years. So we can see this isn't working right. If I was a victim, I would think, what the heck? Probation satisfied that this is as much as she can pay. Well, of course, I'm sensitive to victims. No, I don't feel sorry for you. I feel sorry for them. Especially when you pilfer this amount. But what really burns the court is this urine sample that tests positive for drugs while you're on this court's watch. Really? Really? As 200 years it's going to take you to pay this. Meanwhile, you're going to throw in a little marijuana party in the middle just to enjoy yourself while the victims are suffering. I don't like that at all. That doesn't seem fair. It's not fair. It's not right. And it shows a lack of appreciation or respect to the whole wrongdoing mess. You made promises to this court when you placed on probation. And if I was a victim, I'd go, where is justice? It's not with you. When you're not paying, you're getting high. And there's the two major problems. These people will never get paid in your lifetime, but I was never clear about something on all of this. This $50,000 that you stole from these people, where did it all go?
Ridiculous.
I'm sorry?
Just ridiculous things like clothes.
I don't think anything's ridiculous in this.
It was ridiculous.
In this whole matter. Like what?
Just like trips and clothes and nothing that I have to show for it. It was over many, many, many years.
What do y'all say?
I defer to the probation department, Judge.
Judge, it is a lot of restitution. The payments are going straight to them. They are getting paid. Honestly, she probably won't pay that off in full,
Here's what I
but
want to do. Okay, I think I understand. Here's what I want to do on this first amended motion to revoke unadjudicated probation. Something's going to be done. I'm going to have a meeting here. That's what's. All right, and still have this 2018 motion. That's what's pending. And we're still here because of money.
Yes, restitution, sir.
All right, where are we on this 83609? The Kia Lewis.
Your Honor, for restitution balance as of right now, $6,925 since their last.
Hold on. How much? What's the balance?
$6,925.
What was it originally?
It's 15,000, sir.
So $8,000 has been paid
Yes, sir.
since 2008. Almost 20 years. Is that right? We've been
Yes,
here for 18. Okay. Go ahead.
Since their last court date, she's paid a total of $500 toward restitution. And
What was the last court date?
July 28, excuse me, sir,
25.
Over a year ago?
July
Yes, sir.
10th, 2025.
Okay. Well, that's paltry. So, what can you tell me about her ability to pay?
She's reported she's working, continues to work. She did report to me this morning that she will make a payment after court. Besides
When
that,
was the last time a payment was made?
the last payment was July 28th.
Well, I don't want to have to set a court hearing and have her come to court before she decides to pay something.
Yes, sir.
But what's going on? What happened? Is she supposed to be paying monthly or something?
Yes, sir.
How much?
The last part of the court, she's
My last note indicates $100 a month, Judge.
yes, sir.
Okay. From dealing with her as a supervisor, is she able to make $100 per month?
I would believe so, sir.
So, have you talked to her about why it's not happening?
No, sir. She's living in Houston. Communication is usually when I communicate with her to make sure she knows her court dates are coming.
She had some issues with the online payment this time, Judge. That's why she's couldn't make a payment today.
What do you want to do? From probation?
Your Honor, we have been coming to court quite a bit. Court has been very lenient.
Maybe two.
I would maybe this might be a wake up. I would hope, and then maybe reset her case and see if she can make another very strong payment.
I'm going to ask a motion to revoke probation to get filed. Thank you. Byron Richard.
It can cost to the renovation, okay? Okay, but I'll give it. Not yet.
Byron Richard is called, yes, and 20-34470. There's a first amended motion to revoke on adjudicated probation in this one as well. Let's see, be true in 05. Then the report. Yeah, drugs. Failing to provide verification, completing theft prevention. So on from probation, how's he doing now?
Well, he got sent to safety, sir.
Yes.
And upon his return from safety, he's doing excellent. He's been doing everything we asked him to do. He's been reporting to all of his meetings. He's been working.
What did you learn over it? What is it that you feel has changed you for the better?
I learned
Because safety, I hear it's a good thing. It has.
I had learned life skills and cognitive intervention. That everything is based off time perspective. It's not off my time. It's when the due time is right.
So what's your plan in life?
I plan on going to get my CDL.
Say that again?
Plan on going to get my CDL. Been talking to the people at the work.
Commercial driver's license?
Yes, sir.
What do you want to do?
But I want to haul like cars and stuff
Okay.
and propane for the plants.
Mhm. That's supposed to pay a lot of money.
Yes, sir. Also, every time I'm on color, so
Are you, do you have a family? Do you have children or
Yes, sir.
married and children? A little girl. How old is she?
She just made July 30th.
Okay. You want to set a good example for your child, don't you?
Yes, sir.
It's important. It's the best gift you can give them.
Yes, sir.
What do we do today? Yeah. From probation, you feel like satisfied here? Things are going in the right direction?
Absolutely, sir.
With,
Everything's going right.
Byron?
Your Honor, we also want to ask permission. He wants to move to Harris County.
Why
Because
not?
he has a job opportunity out there.
Yeah, why not?
Sir?
Why not? Any reason why not?
No, sir.
Okay. That's what you
Yes, sir.
feel like that will help you
Yes, sir.
advance?
Yes, sir.
Okay. You still have terms and conditions of probation you got to follow.
Yes, sir.
But even if it's not here, it'll be, we would have to get a courtesy supervision over there
Yes,
to
sir.
make it easy for you, but keep doing what you're doing in the right direction.
Yes, sir. They put me on colors too. Every time they call my color, I take a UA and I've been passing and I've been going all my classes as well in my individuals.
Okay. But remember, it's just not you. You got a family.
Oh,
that
yes,
you're
sir.
supposed to be a role model for, right? An example setter.
Yes,
So
sir.
you got other people's lives
Yes,
in your hands.
yes, sir.
And that should make you even strive harder to do the right thing.
Yes, sir.
And what do we do?
I'm counting that one as a success. I sent you a motion to dismiss the MTRP.
Okay, it shall be signed and done. Okay. Do well.
Yes, sir.
Good luck.
Thank you.
Yes, sir. Thank you. So. I have Kevin Boyle. Kevin Boyle. Eighteen 29525. Hey, I want you to put that case aside that big loss in that woman because I want to talk with the police because they really want that. I want to buy it. I want to stay in on but the motion also. Yeah.
Give the emotion so much.
I know, but it's because it's when we set the here. Yeah, I had asked you said on the ground.
Yeah, that's what I did.
Something up to this debate.
The one that's just so old. Yeah. Gotcha.
Okay. Kevin,
Yes.
Laurel, that's you, sir?
Yes.
Okay, who is the attorney on this one?
I need. You standing in for Mike.
Mike Laird?
Yes, sir.
Okay,
It's a judicial review. I'm not.
it certainly is.
Yes, sir.
I have a report here dated August 5th. And the probation officer, who's Miss Martinez, who's a very nice lady, is sent me something stating that she's concerned with your lack of progress. And she requested a judicial review to address certain things. And that's why we are here. Couple of things when you're here for an aggravated assault, which is a second-degree felony, which carries with it up to 20 years in prison. And the indictment also states you used a deadly weapon, namely a vehicle, in the commission of this assault, which means if your probation happens to be revoked for failure, you were looking at up to 20 years in prison, and you would not be paroled until at least half of that was served. So it's very serious. And this report from Ms. Martinez is concerning. It says the defendant is never reported to the Jefferson County probation office by mail as directed, although you have been reminded multiple times of this. So you can shake, you can, hold on, let me complete it, this, and then you can respond. As of August 5th of this year, a couple of weeks ago, you owe a balance of $45,642.37 in fees and a delinquent balance of $35,000. Of that delinquent balance, almost $37,000 in restitution is owed. You were put on probation, what's going on 8 years ago, right? And what was, so since being placed on probation, really 8 years? About 8 years on probation, Leanne?
Yes, sir. Well, two
Since
2019.
he's only made a payment of $655 in 8 years?
Yes, sir.
It's closer to 7, Judge.
He receives disability in the amount of $852 a month.
Okay, hold on. He was placed on probation January 28th of 2019. This is August. So that was 7 years and 7 months. Over 7.5 years. So you're making a grand total of about $6 a month is what you're paying. At this rate, it could be a while. That's another one. In yours, it'll take 7,000 years.
No, the income, sir. I think.
Yeah, well, I'm not sorry for you. I'm sorry for the victim, the person who was injured in this case.
So
The case, I'm sorry, this case that you pleaded guilty to,
I'm sorry, no one was.
that you
hurt.
pleaded guilty to.
Apologize.
Remember, what you pleaded guilty to in this indictment was knowingly threatening someone with imminent bodily injury, striking their car, but with your car, and then stating, "I'm going to kill you all." That's what's in this indictment that you pleaded guilty to. You can imagine how victimized somebody would feel. So they're not getting their money back and they're lost. And so what do we do?
You're right. I do want to correct the one part. He reported by mail until 2022, and then all of a sudden, he stopped. He has been reporting to Harris County.
This reads, the defendant has never reported to Jefferson County by mail. That was when he came into our possession or into our direct supervision, or?
Oh, yes, sir. Yes, sir. Because originally he was placed on probation here.
So he's never reported to us, but he was by mail, but he was supposed to.
He reported until 2022.
Moved to Houston and was allowed to, and have been reporting there without failure.
Well, what is your total income and where, from what sources? I know we have that, right?
Yes, sir. It's it's disability. He gets 800.
That's it? It's exclusively disability? That's all you Well, these people will never get paid that.
The other issue we had was he's also been seeing the compassionate care doctor, and he's placed on medical marijuana, which was the other reason for this review.
You're not driving a vehicle, are you? Or are you? Do you drive?
Yes, sir, but
What do we do about that? I mean, we're gonna let him drive and he's gonna be using marijuana by medical? I don't think we can do that. He can't drive.
well, I won't use it anymore then because I wouldn't want to give up my license.
Yeah, but you see a problem there? I mean, if you get in an accident with a 4,000-pound missile, which is what a vehicle is, and you're on marijuana, you're using marijuana, there's an issue. You gotta be alert and sober.
Right.
Judge, I'm getting you a copy of the PSI. At the time in which he was placed on probation, the drug history information indicated he was using Kush at that time. So this is not something new.
What is your point? What do you? What do you want to say about it?
I don't approve of any form of marijuana.
Okay. Is there something else he can take? But still, I mean, if it's certain medication, you still got to be careful of getting in a vehicle if it's a controlled substance.
Yes, sir. And he said he takes it for chronic pain. So
CBD is the only thing available now because it took the other off the market, and that's the painkiller.
Then you can't drive a vehicle if you're going to take that. You can't operate a motor vehicle.
I won't. I won't.
I mean, I can see that headline. What court supervised this? I mean, that's dangerous for everybody else. You have to operate a 4,000-pound missile soberly.
Right.
Okay. You got to decide.
Well, there's other prescriptions that people take. And it says, be careful when operating the vehicle. And
Well, what's your point? I don't understand what you're trying to say. You can't look. It's simple. You've got rules of probation you have to follow. Make sure you follow those. If you fail, your probation can be revoked, and you're on deferred probation. You're looking at 20 years in prison.
Judge, not to interrupt you, but I don't believe he's recognizes he has a dual responsibility of reporting. He thinks he's completing it by handling Harris County, but he hasn't reported to us by mail for 4 years.
What about that?
You're
supposed to do. Oh yeah, you did. Everybody knows you did. But
this is the PSI, Judge.
First, I know there's the PSI, but I mean, when we put him on probation, where's the order? Do you have an order with you? Actually, I've got it.
court order, I can.
Oh, I've got it. Okay. Order number part 4, report as directed by your probation officer. Report as directed, you were directed to mail. And this is the order that the court signed. And strangely enough, you signed right under my signature, which states, I've received a copy of the order. I agree to follow all conditions imposed upon me. I know that this probation can be revoked for any violation. So there you go. You've made a deal. You signed the deal. Don't say you didn't know. What do we do? Beat this dead horse all day. What do we do? Let's move forward somehow.
You additionally did the amendment that allowed him, that indicates both levels of the reporting, Judge.
And
You
he and I had a
have
conversation.
to report or else you just the last warning you get.
Yes, sir.
Failure's not an option. Okay.
And I've sent several times the reporting instructions. I resent them again earlier this week to him. So
I tried and I couldn't sign in for some reason, but I'll.
Figure out how to do that. Okay. Because it's an obligation you have, so.
Yes.
And we also discussed the medical marijuana. So. And I explained to him, you can't, if you don't feel comfortable giving anyone permission to use any kind of drug and get behind the wheel. So he's gonna have to figure something out.
Okay.
Talk to his doctor.
You gotta follow those steps.
Okay.
Okay, if there's a problem, let me know. I want to review this in 4 weeks just to make sure all is well and in the right direction. If not, okay.
Other than that, he has completed anger management and defensive driving and thinking for a change, so. But
Okay,
it's the other issues.
all right, Kevin, get a reset. Thank you. Work with that lady. Her goal is to be successful with you on probation. Emily Jones.
Yes. No, Ellie will send an email.
That's safety review, Judge.
Safety review. We now call cause number 236001, the state of Texas versus Emily Jones. You're Miss Jones?
Yes, sir.
Present. And how are you doing? Overall on this, what do you think? Do you feel good about it?
Yeah.
The progress?
Yes, sir.
Is it progressing? Okay, you went to safe peace, substance abuse, felony punishment?
I misled you, Judge.
That's not-
That's not correct. I'll let the probation officer kind of give you the background here.
Okay, play like he didn't say any of that. Yeah.
She didn't go to Safe P. She was ineligible because she was pregnant at the time.
Oh, yeah. Okay,
So she did 180 days in the jail.
then. But once again, she was placed on probation back in 2021.
Yep.
That's right. So it's been over 5 years.
Yes.
And other. How else are we doing on things? Restitution, where are we on that? Because this was an accident involving.
Yes. So as of right now, she owes $3,788 to restitution. However, she has not made a payment since September of 2024.
Why not?
Yes,
I'm sorry?
that is correct. The reason being is that I was under the influence for August until October.
Under the influence of what?
Marijuana.
Why?
Um,
That's not what I ordered. Was,
yes, sir.
that was your choice.
Yes, sir.
So why,
I struggled with substance abuse.
what do you mean by that?
Oh.
It's a simple yes. It's a simple, yes, I will do this, or no, I won't do this.
Yes, sir.
A choice all of us make every day, numerous times.
Yes, sir.
You decided to make the wrong choices.
Yes, I did.
Well, that doesn't absolve you from following these terms and conditions of
Yes,
probation
I
just
know.
because you made mistakes consistently. Okay.
I am taking accountability that I was under the influence.
Shame on you.
Yes.
But what about the people you owe restitution for? For example, while you're getting high, they're suffering a loss that you were supposed to pay. Do you see anything wrong with that?
Yes, sir.
So what are you doing about it?
When I get taxes, I'm going to pay all of restitution up.
Say that again?
When I get my taxes, I'm going to pay all of restitution. I was in jail.
Wait a
for-
second. When you get your taxes,
Tax refund, Judge.
you may,
Refund.
Yes,
when you
sir.
get your taxes, you pay your taxes.
Well, I'm.
You're talking about a refund?
Yes, sir, the refund.
If you get a refund, not everybody gets refunds. All right.
We are going on September 9th. We talked to Ms. Marilyn Hampton at that time. We had to wait for view paperwork to come through. A PO box.
What,
Intern.
what are you expecting to get back from the IRS?
With my two sons,
What are you expecting to get back from the IRS?
7,000 roughly. With my fiance.
Which I can pull that off. I've never gotten such a thing. So with that $7,000, if it comes in,
A total of 3,568, is that correct?
you've discussed all this with the probation officer and she knows what the plan is. Okay.
So instead of sending her to safety, Judge, we've got a suggestion about how to continue the positive steps that she's made through the probation department. If you'd like to hear those.
Go ahead.
So I feel like her mental health supersedes the need for substance abuse treatment at this time. So
What are we gonna do?
I'd like for her to be placed on the mental health initiative caseload. That way she can focus more on her mental health, and then she can also.
She's not insane or incompetent.
No, sir.
Okay.
And then,
Everybody agrees with that.
Yes, sir.
and she can also be placed on the drop program so that her substance abuse can still be monitored.
And I'm in favor of that, Judge.
Okay.
The time in which we dealt
Sounds
with her back in February, I was a little harsh, but it's
That sounds good. The $7,000 that she claims, have you verified that?
I am going to get you a tax refund as soon as we complete it on
No.
September 9th.
No, that's not what, you're using the wrong terminology.
I'm sorry.
Okay.
We want you to give her the pay.
The expected refund.
Expected, yes,
information.
sir. Okay.
But where are we, again, what's the balance owed on restitution?
About 3,700, Judge, roughly.
Oh,
3,788 to be exact.
are you telling this court, subject to any punishment of not telling me, truthful, that that amount is going to be applied toward this restitution?
Yes, sir.
Okay. What else? That will, so the restitution is less than 4,000, between 3,000 and 4,000. She's getting $7,000 back. What's in the difference? Where's that going to go?
The difference, I'm getting a vehicle.
Are you going to buy a vehicle?
Yes, sir.
Okay. Do we have any other arrearages? Or is it just restitution that's behind?
It's just restitution.
Good. I want those people paid back as soon as possible.
Yes, sir.
When are you supposed to, do you know when you're expecting the
September
refund?
9th, we go finish the paperwork with Ms.
Okay, you still are working on the paperwork. That's going to take a while.
She had to get
We just turned in the two paperworks we owed for when I was incarcerated. I wasn't able to open my mail that I received the IPN. Is that correct? Okay.
Yeah.
I didn't open it, and it was sent to my mother's house.
Okay.
So.
All right. All right. What should we do today? Anything else today?
We need you to approve those amendments, Judge, to place her on the mental health initiative
Do you have
caseload.
documents for me to sign?
We'll need to prepare it, but
Okay, I will
we're
find
asking that you
those.
approve that.
And she's fully aware of what the plan is that.
The two-step, the drop program and the mental health initiative.
All right, be successful with that. It helps you be a better person. Yes, and again, keep the probation office updated on the refund so we can get those people paid as soon as possible, because every day they're out of restitution, it's costing them money. They're losing the value and the ability to use that money like interest. We should, I think the rule in all fairness, there should be interest applied for the lack of time people don't get paid restitution, but that's not the law.
Maybe we can put that in the law.
Yeah. Whatever you can do to help in that regard would be nice, yeah. But paying this thing, this back to these people, that's a big step toward purging yourself of the wrongdoing. Okay. Again, I'll see you back in a few months for review. Okay. Let me know about that money thing. I want to celebrate with everybody that the victims get their money. Okay, thank you. Get a resetting. Valerie Levener.
Okay.
All right.
Silent.
15-21647 is calling Valerie Lever. That's you. I recognize Ms. Leverance. All right. Restitution from the beginning, and the defendant has been on probation for over a decade. We're talking about 11 years now. And it's all about money, right? The restitution, where are we?
Since the last court proceeding, Your Honor, she only made one payment. And that was earlier this week in the amount of $1,002.
Okay. And when was the last time we were?
February
In
13th.
February.
Yes.
So what is that? That's 6 months, a half a year.
Yes.
You've had her on a rotating review in 6 months, Judge.
What is the balance on the restitution?
It's $20,435.06.
I'm sorry.
$20,435.26.
That's the balance.
Yes.
Well, it was 60,000 at one time, so it's written down to a third. It's better than some folks. Okay, so, well, what happened here on the delay?
I didn't have access to online and there's other things coming up. I'm not making excuses, but I did, you're Miss Lee. Okay, sorry. They changed that, so I didn't know. I did talk to her when I made that payment and she did give me access to online so I can start making the payments instead of having to drive to Walmart to make them.
Okay, so are you gonna do this in a monthly?
Yes, sir.
How much are we,
I'm gonna try to get back for the original $650 that I had agreed to pay for.
which was what?
$650.
She agreed to that back in 24.
650, you said?
Yes.
Yeah. Well, that would be nice because that, that would, end up getting this thing over with in 2.5 years.
She's been averaging about 3,000 a year, just looking back roughly at my notes, Judge. It's a lot better than some, but not exactly where we need to be.
So, I mean, but again, we're still owing 8,000, right?
$20,435.
Okay, but she's at her rate, she can pay 8,000 a year at the rate. That's 7, 800. Get back to that. Also, otherwise, the restitution we get about this. Hopefully, all that work and let's move forward and get people paid.
Yes, sir.
Last check. Hooray.
I'll join you.
Okay. All right, get a reset. Thank you. Philip Parks.
I wouldn't really switch the last thing I'd asked them. I think we're going to use.
On Philip Parks. This is 17-28417.
This is by my notes, this is a review. There's not only TRP pending, Judge.
It's all money. It's money day today.
I don't know about that.
Okay, you're Mr. Parks,
Yes, sir.
and you've been on probation now. Let's see. It's been 4 years. 4 years. You're on probation 5. But this restitution is a big thing. And I'm curious, where are we on the balance? I'm just looking at a balance here from an administrative hearing of 3 years ago. So things have made right to the day too.
Well, actually, in the last 6 months, I've been unemployed for a few months. I lost my job back in March.
What were you doing?
A mechanic.
Automobile?
No, build heat exchangers.
There's a demand for that.
And nobody ever knows what that
There's
is.
a demand for that. Huh?
Yeah,
But that's industrial.
yes,
You're doing industrial stuff.
yes, sir.
Well, that was paying pretty good too.
Yeah, it was. But due to my medical conditions, I had a lot of time off from work. And by the time I went back to work after the operations and all the procedures, I learned that they had let me go.
Medically, physically, are you in good shape right now?
I hope so. I'm praying.
Well, that's what I say every day too.
Yeah.
What's your doctor say? You're ready to go back to work?
They did.
Okay,
They
good.
did.
Well, that's a good thing.
We went back to work at a different company about a month ago. But still doing the same kind of work. He said it shows to be promising and
Are you employed with them?
yes.
How much are you making an hour? Or is it salary?
$27.30.
I'm sorry?
$27.30 an hour.
Okay. Well, that's about 40 grand.
I hope so. If I don't have to miss like I've been missing. But hopefully it's going to be promising. I'm speaking positive about the whole thing. So
what's the balance owed?
The remaining balance owed is $31,685.55.
Okay. And it looks like only about 2,000 was paid since in 3 years. Okay. How long have you been off of work with the other people?
about 4 months.
You get back to work, how much are you able to pay?
We had it set at,
monthly?
we had it set at 500. I'm comfortable with that.
You can do that, you think? Because that's 6 grand a year.
I know.
That's 6,000. You owe 31, so we're looking at 5 years. Well, what probation satisfied
Yes, sir.
on this plan? Okay, good. Do the best you can in good faith, sir, and this is all that's holding this probation up is the restitution. You
Correct.
get this paid back and then we celebrate.
No,
And it gets, this case, you're on deferred probation.
Right.
This thing gets dismissed,
Right.
not just terminated with a conviction. You get dismissed so that it purges you. All right, let's get to the finish line. All right, we'll review in 6 to see where you are. Thank you so much. Kenneth Randolph was reset, it looks like. Bryson Swanson is called.
Okay.
Swanson.
Oh, that you?
Yes, sir.
Okay, in 22-409-10, you're on probation, right?
Yes, you're on.
For deferred probation since.
Deferred probation.
3 years,
March of 22.
3.5 years. And Mike is here.
It was a safety aftercare review.
Oh, okay, and?
He was doing well up until.
Uh-oh, that's what it was.
Up until August 21st, where he picked up a new EW.
You mean a couple of days ago?
Wait, last week. Yeah, if I may be heard on, Judge, whenever you.
So from probation, what happened? What's your version?
He was doing very well. He completed all safety and aftercare, and then he was placed on the transitional treatment caseload, and he was doing well up until
The other day.
Yes,
And
sir.
then what happened on the other day?
You got arrested with DWI.
DWI.
What's the circumstances of it? Do we know?
I have the offense material.
Let me look at it, please. Some DWIs are less serious than others.
Yeah, I haven't
Some are
seen
more.
the discovery yet on DWI.
So he tested at 0.06. See worse. So there's that rustling. You have the old abstain from all intoxicating substances, including alcohol, as a condition of probation. It doesn't say you get to drink a little bit. It says abstain from all. Here you go. Can we make a copy for Mr. Smith so he knows? Otherwise, now that's not a minor problem, but otherwise he's fine.
He'd been doing well. He had a few, he's on drop, so the color code.
Yes, sir.
He missed a few.
So what do you suggest we do from probation here?
So we did file an administrative hearing requesting a motion on Monday.
Okay, so where are we headed on this? So everybody has an idea. What's the state want to do on this?
So Judge, I
know
have
you saw
not
a motion,
received, yes, I have not received it, so I had not seen that report or aware of that either. So I would like to review that before making a decision.
If it was sent in our office, it takes a minute to get to us.
Judge,
I'm going to look at it in 3 weeks, but what are we doing to fix all this?
Your Honor, if I could, I'm suggesting that we might consider putting him on the mental health caseload.
Why?
Because he's now receiving treatment for a major depressive disorder, generalized anxiety disorder, PTSD, and also agoraphobia.
Agoraphobia?
He has agoraphobia.
Okay. Oh, well, some do.
And so that's what.
Don't wear a sweater.
The couple of times that he missed the color code time was because of the agoraphobia, which he's now being treated for. But
how does that make him miss the time?
You're afraid to come out of the house. But he's doing the best he can because he has a full-time job.
Well, how's that work? Is he missing work?
No, sir. He's in.
When he goes to work, he can leave to go to work, but he can't leave to go to the probation office?
No, just it comes and goes, Judge. It just.
Has he ever had a problem with work? Have you ever had a problem going to work with agoraphobia? But you have a problem going to the probation office?
It was that one day that I was, it's been like a mental health problem, but
it's only happened one time, isolated time thing here?
Yes, sir.
All right, well, that's.
On the cover, I thought you only missed one time.
I believe it's 3.
I called him to get permission the other times. Because I was at.
Well, look, here's the deal. We got requirements and there's a good reason. Generally, the reason people don't report is not a good reason. They don't want something to be tested. And that's generally why they seem not to report unless they are hospitalized. Because we see this over and over again. Some things repeat themselves. So we know how people can be. But you've got requirements here that you have to follow. And you're looking at, up to 2 years in the state jail and a conviction if you foul up. So we don't want to do that, right? No, I don't want you to, and you don't want it.
I got, I've been making progress in my life, so.
We have more than that. You have responsibilities at home, don't you?
Yes.
Yeah, I mean, here recently, Judge, you allowed him to exercise visitation pursuant to the terms of the family court order.
Yeah.
Which is the first time in a long time that has occurred. So he's been doing so well. And
what was the date on this event we're talking about here on the agoraphobia episode?
That was the 20th
of
last week.
Oh, just last week. Okay. Well. What are we worried about for, is it alcohol use, drugs, or both?
For safety, and he can correct me if I'm wrong, his drug of choice was fentanyl. So that's a big concern.
Okay, it's so simple. If he's not able to report because of something, put him on a drug patch. And we'll test you, and you can't claim agoraphobia when it tests positive. But you're gonna be held, we're gonna figure out a way to hold you responsible. And the drug patch will be tested and it shows positive and SOI. Shame on you. Okay. What do you want to do today? Anything?
Judge, I'm asking that he be required to get the drug patch. I'm asking we put a deadline on him to put the drug patch on. I know today is Friday, it's going on 11 o'clock. And that
That's done at the office, at John's office or at probation, right?
Johnny's.
Oh, Johnny's Auto. Gotta love it. Is Johnny open during the weekend for business?
It would have to be Monday.
I thought Johnny had some of these in there all the time.
They're in the office this afternoon, Judge.
Unless he's open this afternoon.
Get it done today. Okay. If there's a problem with it, first thing Monday. But my preference is to get it done today and verify it with the probation office before the end of the workday, which is that they leave 4:30-ish or so. So, okay, just fix this. You don't want to lose out. Okay. All right.
Thank you.
Yes. Oh, thank you.
Judge, can you reset this? I mean, I know it's coming down, you come down.
Y'all got an MTRP coming down, but yeah, let's review the status and we'll see where we are in 4 weeks.
Can we hold off on the NPRP filing?
I don't know where they are on it. But
I think probation officer said he requested that of you.
Yeah, I haven't gotten it. I think it's.
If they send it in our office, Judge, it probably either just made it to our office or
It's working its way
it's
around.
working its way here.
It's lost in traffic.
Days.
It's
So-
stuck on the freeway. I'll hold it in abeyance until we have that review.
Great, thank you.
Okay, thanks, folks. Eric Sames. Thing, fourth place in number sense. State champion. Okay. 13-16435 is called Eric. Is it Thames or Thames? And you're here with the probation office, and this is another restitution because we started out back in 13 years ago, and you owed over $20,000. And where are we on restitution balance today?
I believe 3,400.
Sir?
I believe 3,400.
Is what's left?
I received an email. I'll let the probation department speak to me.
He's got about $3,014 left in restitution to pay. His total balance for everything is $3,400.
Well, when's the celebration day of paying it all?
I want to go for my birthday.
Okay. Well, you're paying a little bit each month?
Paying 300 every month.
Okay, we're gonna keep that up?
I collect work.
Okay, then why don't we review this in 3 months to see where we are?
Yes, sir.
Thank you.
Okay, it sounds like we're getting to the end.
You don't want to do 6 months, an hour.
No, I want to see where we are in 3 months to make sure that we're keeping the momentum.
Oh, absolutely.
And that's all. But just make what is the minimum at least or more. But if you happen to be able to pay it off, you get in front of me and you're on deferred, right?
Yes, sir.
When that gets paid, I mean, there's nothing else standing in the way of a dismissal.
Yes, sir.
So I was kind of hoping for a Christmas gift,
Yes, sir.
if
Pardon?
possible. I was thinking of a Christmas gift, if possible, if possible. If you can do it, the moment you can get that done, they'll send it to me and I can get a dismissal signed and then you're free man.
Thank you for the opportunity.
Yeah, well, just keep fighting the good fight and moving forward.
Will do.
Yes, sir. Okay.
Thanks, Judge.
Thank you.
Thank you. Bye. Is
That resetting, please.
that it? Anybody else? No, one more. You got one. You, sir, or whom? Come forward, please. Who is, I don't have any files left and I don't have, what's your name, sir?
Cornelius?
Oh.
I think his case was reset. I think this is Barry. I think he was on the docket previously, but I think he was reset.
Cornelius? I'm looking, I didn't see a Cornelius on the docket today. No. No.
Move to October the 9th.
Sir, yeah, come on up, sir. For whatever reason, that had been moved to October 9th. I didn't, but I don't know what that is all about, but it wasn't on this docket, but thank you for being here. What's your status? Okay, you're on probation? Yes. Well, where are you on that?
I don't know. Been paying $70 a month.
For how long? Years?
No.
What did
want to say about 6 months, 8 months.
how much do you have to pay total? What's left?
I think it's 4,000, but they several incidents. They said $1,000.
Okay. So how much are you paying a month, you said?
Right now, 75.
75, okay. Well, you can do the math on that at 75, for 4,000. Per.
I think she said we settled at $1,000.
Sir?
So for me to pay it off $1,000, then say like throw it out, dismiss the case.
I don't know, but we never cut short restitution. Restitution.
No, that restitutions.
Oh, it's on all payments?
Yes, sir.
Oh, okay. Okay. Yeah, I have to look at it to see, but I reward people to pay it off. And the quicker you pay it off, the quicker you can move on with your life and take care of personal business and not be up here. All right.
But come on, this way.
Anything else from anybody? Yes, no?
All right, so we're gonna go back on the record. We have one last matter left. The parties are here in the courtroom. The bailiffs are not. They're apparently busy downstairs standing around. But we'll address this matter. It's entitled Janice Ferguson versus Eric Odom. File number is 261292LT. Are you Janice Ferguson?
Yes, I am.
And you're Eric Odom?
Yes.
All right, will you both please raise your right hand? You will swear or affirm that any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes. Yes.
All right. This matter has to do with a double wide home on River Heights Road, and I've dealt with this property before. Ms. Ferguson served a notice to quit on Mr. Odom, who I believe is her nephew, regarding this property. The defendant filed a long letter explaining some things. This matter was set for a hearing. There's no lease here, by the way, either, as far as I can tell. Everything is either done on a handshake or he said, she said, but the plaintiff filed a motion to terminate the tenancy. That was filed on June 12th. As I indicated, the defendant did file an answer. We had a hearing on August 10th. The defendant did not appear, excuse me, that was on July 31st. Last day of July. The defendant did not appear. I entered a default judgment against Mr. Odom. I asked some questions of Miss Ferguson when she was here. She said there was no lease. The defendant has been there for 2 years. Her husband died and she moved there. Her nephew was there. Eric stopped paying, still there. Also, his stepkids were there and no one will answer the door. She indicated the last payment was made about 6 months ago. Defendant failed to appear and a default judgment entered on August for a move-out date of August 10th. Defendant has filed a motion to set aside that default. He contends that he was here or attempted to log in by Zoom and was unable to do so. I don't know where he was, but he wasn't in my queue and I never brought him in from Zoom. He indicated he had called the court several times that day for instructions and other concerns. So one, he may have a legitimate reason for not appearing. Two, he claims that there is a legitimate defense to this. He represents making a $5,000 payment and $3,200 payment to Miss Ferguson, making this more like a land contract or something rather than a lease.
He's never given that much money.
Yes, we did, the down payment right at my sister's.
All right, well,
house.
let's back up. All right, Miss Ferguson, how long have you owned this property?
30 plus. I would say.
Somewhere around.
Probably 30 plus, Your Honor.
Probably. That's where I lived when my daughter was born.
All right, so you've owned it for many years. All right, Mr. Odom, you previously lived at Memory Lane Mobile Home Park.
Yes,
You moved into this property when?
it was, we've been there almost 4 years. It was around August. I want to say around there.
All right, your last Memory Lanes case was in 2023. And you apparently moved out in October of 23. So did you move out of Memory Lanes into this property?
Yes,
All right. What was the agreement when you moved out of Memory Lane and moved into this
it
double
was,
wide?
you're right. At first it was, more of a verbal, family, it was, I pay the bills or pay the mortgage. If, when it got paid, the house was mine, / if something happened to her, the house was supposed to go to me at that point in time. And, that's how it
All right,
started out.
now, let me talk about that. That's not valid or enforceable. Any contract for the sale of real estate has to be in writing. So it's something called the statute of frauds. You can't do a verbal, well, you can do it, you just can't enforce it. So let me ask from your perspective, you let him move in there, Ms. Ferguson, what was your understanding of the terms of which he was going to live there?
Well, he's my stepson.
Yeah, oh, stepson, not nephew, all right.
Huh?
Yeah, when he was reading the report, he thought I was your nephew.
Oh, not nephew.
All right, he's your stepson?
Yes.
Yes, he's
Okay.
my husband.
All right, so what was your understanding that the conditions in which he was gonna move in?
My understanding was that they were gonna keep it, make the payments on it, live there until they decided they didn't want to live there. I really wanted it to stay in our family.
I'm still trying to stay there.
All right,
I'm
just
not
for,
trying to
just
leave.
only one person could talk at a time.
Sorry.
So there's no lease. He's moved in under some vague agreement that he's gonna live there and make the loan payments and pay the utilities?
Yeah.
Is that correct?
Yes.
And you live in White Pigeon?
I do now, yes.
All right, so he lives there from October of 23 until you file this thing in June of 26 to terminate his tenancy.
And he still lives there.
All right, and so why did you file it?
Well, I had a lot of problems. His next door neighbor was a terrible. Anyway, you've seen her in court too.
Yes, I'm aware of some other neighborhood disputes
Okay.
involving dogs and fences and other things out here.
Yes. And it was just like one thing after another after another.
But that's been called.
All right, so you asked me to make him move out. You served a notice to quit on him. You said you went to the house all the time and knocked on the door. Nobody would ever answer the door, so they wouldn't talk to you.
Yeah, I wasn't sure. There were sometimes cars in the yard, but that doesn't mean anything. But nobody ever answered the door and the dogs would raise all kinds of heck.
All right, so we had a hearing. He didn't show up. He said he didn't show up because he couldn't log in. So the question is, do you still want him to move out?
Yes.
Then what are you gonna do?
I'm gonna rent it. I'm actually gonna rent it to my grandson, who's,
Your Honor,
Just a minute, I'll give you a chance. Well, I hope if you do a better job than you did here. You don't have a lease, you don't have anything in writing, you've got a he said, she said. All right, so let's back up. You have no rights on this property. You don't have a lease, it's not in your name, and the person that owns it wants you to move. So what's your position?
well, right after we moved in, I couldn't turn that, there was a handwritten lease. It was nothing notarized. And all it was is a quick one. Remember, I had to do, the gas company went to turn on the gas in my name because, previous people had back bill. And they went and turned it on, so we did one for that. But I could not get a copy of that again. I tried to because we had to send.
Was that back in 2023?
We had to send it to the gas company, and that was the only ever one that was done. But it was mainly for the gas company because it's always been verbal. As far as the payment wise goes, I can see right here, on 5/13, I made a $3,200 payment towards this house.
All right, on May 13th of 2026.
Yep, I made a $3,200 payment, and then I can show proof previous to that where on somewhere I've been paying the house payment. I've paid the property taxes. There is some behind, but it wasn't like behind where they're taking it because I've been keeping up with them. But I paid $3,000 just prior to paying this 3,000 or 3,200. I paid $3 here for the property taxes, and then 3,200 for the house payment on 5/13.
Well, that's commendable. The problem is you don't have a lease. You paid $3,200 toward the house. I'm not sure, well, for what period of time that was, and you paid the property taxes. But you don't own the house and you don't have a lease.
Well, I understand. That's why I don't understand what if I'm just holding up to my end of the bargain. I've never went to you and asked you to like help me out with that sort of thing. I've always managed to take care of it. I've dealt with the house. I've held up to my end of the bargain. I'm not saying it's always been perfect. We were family. I was handling my business without like involving you. I know it's stressful at times for you. I understand that part of it because you got where you live at, and then this is on your shoulders. But I've always handled my business with you. I've never not lied to you when it comes to this house. I've always been fair with you. And yes, there was issues with my neighbor. We all aware of that. That has all been calmed down. When we first moved in there, I had a wild child. My son didn't help with the neighbor dog situation. So that's kind of, I dealt with the wild child for a couple of years.
Yes. Now, are your stepkids still there?
One stepkid is, and his girlfriend, and then occasionally my 10-year-old's there. I share with them.
All right. You may have a legitimate reason for not appearing, but you don't have a defense. You don't own the property and you don't have a lease. So you're there as what's known as a tenant of sufferance. You are foolish. You let him move in there with no lease, no contract, no nothing, just sort of a handshake. Well, the handshake hasn't worked out. You have more rights than he does because the property's in your name and you want him to move. He apparently has made payments on this property, which has given you equity in it for 3 years, give or take. I don't know. Are you getting the notices that you're behind on your payment from the bank?
No, not anymore. I was.
I just got the bill last night and here it is. It's $2,000 behind.
All right.
2,000 feet.
Because after I paid that 3,200, that gave a little bit extra for the next payment. And I went to pay it and it would not let me. And
All
that's
right.
when you guys switched the name, took me off the account.
Well, that's no longer your problem.
I know.
That's her problem.
I was just,
Yeah, this is unfortunate. It's a family situation,
yeah, because
but
I dumped all, I mean, I don't have no money to move right this second because I've been dumping it all to try to save this and
well,
and that's where I'm at. I'm not trying to be.
I understand. That was back in May. June, July, and August have passed. I don't know what you've done with your money since then. Right now, nope, but in fact, once she filed this motion to terminate the tenancy, she's not supposed to accept any money from you. She doesn't have much of a leg to stand on if she sues you for money because you don't have any contract between the two of you for the monthly payment or that sort of thing. So my recommendation is you don't make any payment on this house. But she has the right to terminate the tenancy because she owns it and you don't have a lease. So a good and meritorious defense were not presented. Defendant has no lease. Plaintiff wants possession. Now, we had that hearing on July 31st. I gave you until August 10th to vacate. It's now August 27th. So you've had, because of your motion, that sort of put things on hold. Motion is denied. Plaintiff may ask for writ of eviction 10 days from today. After September 7th. So you can come up here on September 8th with $15 and ask for an order to have him put out of the premises. And all occupants. The law says you have 56 days from today to do that. You don't have to evict him on September 8th. You have 56 days from today to ask for the writ of eviction. But that's what this whole summary proceedings is about, to allow the plaintiff to get a court order.
Will I get something in writing explaining that to me? Because my memories.
Well, I'm going to give it to you right now,
Oh,
this
okay.
order setting aside the motion to
Okay.
set aside the default. Hi, are you there by yourself? Well, I've got a proceeding with people in court and I was looking for some bailiff help. So you guys must not be watching the camera. All right, thank you. Bye. Okay. This is all unfortunate. You've paid 3 years worth of payments to live there, but assume that that's rent.
Yes,
So
yes.
you paid payments for the
Yeah,
privilege of
I'm
living
not
there.
disclosing that. I was just,
You haven't paid June, July, August, and you won't pay
well,
September.
I attempted to, and that's when,
All right, well,
because I was paying the house mortgage, not her.
All right, at this point, don't pay anything.
Okay.
She wants you to move. She's gonna have a hard time suing you for money damages because we don't have any sort of written contract. If I were you, I would just get prepared to find a place to move to. That's easy to say and hard to do.
Yes, yes, and that's been.
Because there isn't anywhere to move to.
Yes, because look around us, we have a lot of people, yes.
Yes, but apparently there's already somebody ready and prepared to do this. If you move somebody in there, get a lease.
I will.
Go talk to an
Actually,
attorney, have
somebody
somebody
that's-
help you draft a proper lease.
Somebody that's gonna move in there is planning to buy it.
All right, well then file,
they'll
then have a land contract or something drawn up, some sort of legal document. As I indicated, you can't do an enforceable contract for the sale of real estate unless it's in writing. So Mr. Odom, you're in a tough spot. You got 10 days to vacate, or she can ask for a writ of eviction. She does not have to ask for a writ of eviction for 46 more days after that day. So you can give him some grace time to get out if he says, hey, I got a place to move into, but I can't move into it till.
Yeah, because I got almost like I said, I got a garage full of stuff. The house is big. It's it's a big house, so yes, I got a
Yes,
lot of stuff.
I've been there, just in some of those earlier disputes. I
It's
drove
just
out there.
me dealing with it, as far as that part of goes, as far as the moving part. It's me, my wife's,
All right, well, at this point, you're living there for free, without any payment, which is some benefit, but you can't stay there indefinitely. She has another renter she wants to rent it to. My same advice to you, if you rent something, get a lease, get something in writing. If you have, what you sort of had was a land contract that you were gonna make the payments and then you were gonna get the property. But you have to do that in writing. Otherwise, you might have more rights. You would have maybe up to 90 days or even 180 days to redeem it. But we don't have anything in writing that I can use to enforce. So your motion to set aside default is denied. And the plaintiff may ask for a writ of eviction after September 7th of 2026. I guess the bailiffs are otherwise occupied doing I don't know what, but I'm gonna send you out to the counter. You each get a copy of this order. I wish I had a better answer for you, but I don't. I wish I had a bailiff, but I don't. Here he is. All right, thank you. I'm gonna ask if you take these parties out to the counter so they can each get a copy of this. Thank you. All right, you're both free to go.